In the state of Florida, sometimes a buyer may find themselves needing to back out of a signed and executed purchase agreement. Here's a detailed story that explores all the avenues a buyer might take to exit such an agreement. For personalized assistance, call your trusted South Florida agent Irina Tolmacheva at 561-406-0717 or email her at rentbypalmbeach@gmail.com. The Tale of the Sunset Escape. Once upon a time in the Sunshine State, a buyer named Alex found the perfect home nestled in the heart of Florida. After days of contemplation, Alex signed a purchase agreement, excited to start a new chapter. However, as fate would have it, circumstances changed and Alex needed to find a way out of the contract. 1. The cooling off period. In Florida, certain contracts allow a cooling off period. For residential condos, there's a 15-day rescission period where the buyer can review all transaction-related documents and cancel the contract if necessary. 2. The job loss clause. Alex discovered that losing a job could be a valid reason to terminate the agreement. A sudden job loss would affect the ability to secure a mortgage, providing a potential exit from the contract. 3. Mortgage application denied. If Alex's mortgage application were denied, this could also serve as a reason to back out. Many sales contracts include a clause that allows buyers to withdraw if they fail to qualify for a mortgage. 4. Inspection issues. Problems discovered during the home inspection could lead to a deal breaker. Alex could use significant inspection issues as leverage to negotiate an exit from the agreement. 5. Appraisal contingency. An appraisal lower than the purchase price could trigger an appraisal contingency, allowing Alex to renegotiate the price or back out of the contract altogether. 6. Home sale contingency. If Alex had a contingency that the purchase was dependent on selling a current home and that sale fell through, it could provide an escape route. 7. Force majeure. A force majeure clause could release Alex from the contract if unforeseen events like natural disasters or other acts beyond control prevented fulfilling the agreement. 8. Seller's breach. If the seller failed to uphold their end of the contract, such as not making agreed repairs or not meeting deadlines, Alex could opt to terminate the agreement. 9. Legal counsel and contract provisions. Consulting with a real estate attorney, Alex found specific provisions within the contract that outlined cases permitting contractual rescission. 10. 3-day business rule. In some cases, Florida law allows buyers to cancel their purchase for a full refund until midnight of the 3rd business day after the sale. As our story unfolds, Alex navigates through these options, seeking the best path to retreat from the purchase agreement. With careful consideration and legal advice, Alex finds a way to gracefully exit the contract, ensuring a happy ending without penalty. And so, the tale of the Sunset Escape reminds us that in the complex world of real estate, knowing your rights and options can lead to wise decisions and, when necessary, a timely withdrawal from a binding agreement. Remember, each real estate contract is unique, and the ability to exit such agreements depends on specific terms and conditions. It's always recommended to seek professional legal advice to understand the full scope of your options. In Florida, the cooling off period is a consumer protection mechanism that allows individuals to cancel certain contracts within a specific time frame after signing them, without penalty. Here are some key points about the cooling off period in Florida. General Cooling Off Rule. Florida law entitles consumers to a 3-day cooling off period for contracts signed for services to be rendered continuously in the future. This means that within 3 days of signing such a contract, a consumer can cancel it without financial penalty. Home solicitation sales. If a purchase of goods or services is made during a home solicitation sale, which is not at the seller's main or permanent place of business, and the purchase price is more than $25, the buyer maintains a 3-day right to cancel. This must be done in writing by no later than midnight of the 3rd business day after the contract date. For residential condos, there is a specific provided by state law. During this period, a buyer can review all transaction-related documents and cancel the contract if necessary. Federal lending laws applicable in Florida give you when refinancing a mortgage on your primary residence with a new lender. This does not apply to cash-out refinance loans. It's important to note that not all types of sales or contracts are subject to the cooling-off rule. For example, the rule does not apply to the sales of real estate properties, insurance, securities, or artwork sold at fairs and other public places. If you're considering using the cooling-off period to cancel a contract, it's advisable to send written notice to the seller by certified mail, even though it's not required by law. This provides a record of the cancellation and ensures that you meet the deadline. Refunds for canceled contracts must be received within 20 days after the seller gets the notice of cancellation. Always remember to check the specific terms of the contract and consult with a legal professional to understand your rights and obligations fully. The cooling-off period is a valuable right for consumers, but it's essential to act within the legal timeframes and procedures to utilize it effectively. If a seller in Florida refuses to honor the cooling-off period, the buyer has several options to enforce their rights. First, the buyer should ensure they have provided the seller with a written notice of cancellation. This notice must be sent within the cooling-off period and is best sent via certified mail for proof of delivery. Next, the buyer should review the contract terms to confirm that the cooling-off period applies to their purchase and that they have complied with all necessary procedures. If the seller still refuses to cancel the contract, the buyer can contact consumer protection agencies for assistance. In Florida, the Attorney General's Office and the Department of Agriculture and Consumer Services can provide guidance and support. As a last resort, the buyer may consider taking legal action against the seller. An attorney can help the buyer understand their rights and the potential for recovering any losses or enforcing the contract cancellation. It's important to note that the cooling-off rule is designed to protect consumers, and sellers are legally required to comply with it. If a seller is found to be in violation of this rule, they may face legal consequences, including penalties and the requirement to refund the buyer. If you find yourself in a situation where a seller is not honoring the cooling-off period, it's crucial to act quickly and seek professional advice to ensure your rights are protected. The case of the overlooked cooling-off period. In our story, let's consider a buyer named Jamie, who recently attended a home solicitation sale in Jupiter, Florida. At this event, Jamie was persuaded by a charismatic salesperson to sign a contract for expensive landscaping services totaling over $1,000. The contract was signed at Jamie's home, which falls under the scope of a home solicitation sale. According to the Federal Trade Commission's cooling-off rule, Jamie should have been given 3 days to cancel the contract for a full refund. However, the salesperson neglected to inform Jamie about this right and did not provide the required cancellation form. Realizing the oversight the next day, Jamie decided to cancel the contract and sent a written notice to the company's address via certified mail. Despite this, the landscaping company refused to honor the cooling-off period, claiming that the contract was final and binding. Jamie then reached out to the Florida Attorney General's office and filed a complaint, citing the violation of the FTC's cooling-off rule. The Attorney General's office intervened, reminding the company of its legal obligations to honor the cooling-off period. The company was eventually compelled to comply, and Jamie received a full refund. This example illustrates the importance of being aware of consumer rights and the steps to take if those rights are not respected. In real-life situations, it's crucial to consult with a legal professional to navigate such issues effectively. Yes, there are penalties for sellers who fail to honor the cooling-off period in Florida. The Florida Attorney General's office outlines the consequences for such violations. Sellers are legally required to provide written notice of a buyer's cancellation rights at the time of the sale. This includes both future consumer services and home solicitation sales. If a seller does not comply with the cooling-off rule, the buyer can file a complaint with consumer agencies such as the Attorney General's Office or the Florida Department of Agriculture and Consumer Services. sellers must refund any payments within 20 days after receiving the notice of cancellation from the buyer. Failure to do so can result in legal action and penalties. If a seller violates the terms of the cooling-off period, they may be subject to contract rescission, which means the contract is considered unmade under the law. This can lead to further legal implications for the seller. Continual disregard for the cooling-off rule can lead to investigations by consumer protection agencies, which can impose fines and sanctions on the seller. It can also negatively impact the seller's business reputation and lead to loss of consumer trust. It's important for sellers to understand and respect the cooling-off period, as it's a legal right provided to consumers. Violating this rule can have serious consequences, including legal and financial penalties. Buyers should be aware of their rights and take action if they encounter a seller who is not honoring the cooling-off period. When sellers in Florida face accusations of violating the cooling-off period, they may employ several common defenses to justify their actions or mitigate the situation. Here are some of the defenses they might use. A seller might claim they were unaware of the buyer's right to a cooling-off period, or that they did not know the sale fell under the conditions that require such a period. Sellers could argue that any misrepresentations were not material, and thus do not support a fraud claim. They must demonstrate that the information withheld or misrepresented would not have significantly affected the property's value. If the buyer was already aware of the defect or issue that the seller failed to disclose, the seller might argue that there was no need to disclose it, as it did not affect the transaction. Sellers may defend themselves by stating that the defect was readily observable, or that the buyer should have noticed it during a reasonable inspection of the property. Some sellers may point to clauses in the contract that call for mediation or arbitration in the event of a dispute, arguing that the buyer should resolve the issue through these channels rather than legal action. Sellers might invoke a force majeure clause, claiming that unforeseen circumstances beyond their control made it impossible to honor the cooling-off period. A seller may assert that the buyer did not follow the proper procedure for canceling the contract, such as not providing written notice within the specified timeframe. The seller could argue that the cooling-off rule does not apply to the specific type of sale or service provided, as there are exceptions to the rule. It's important to note that while these defenses can be used by sellers, they are not always successful. The effectiveness of a defense will depend on the specific circumstances of the case and the evidence presented. Buyers who believe their rights under the cooling-off period have been violated should seek legal advice to understand their options and the best course of action.